So, welcome. It is time for the Bylaws Resolutions Committee, Advisory Committee meeting. Today is March 10th. We are a hybrid meeting. We have both virtual and in person. So I call this meeting to order at 1:00 p.m. Is everyone, I will ask for consent to record the meeting. Is everyone okay with that?
Yes.
All right, thank you. And then our next item on our agenda is we always introduce ourselves for those, especially for the recording, so that everyone knows who we are. We'll start with the committee members first. My name is Laura Pangratz, and I am the committee chairperson. I am I've been an owner in Ocean Pines for about 8 years, full time for the last year, 12 months. And on this committee, I think almost 2 years now. I think time flies when we're having fun. So I'm going to ask Bob to introduce yourself. Let's say who you are.
Yeah. Bob Hilligus. I've been a resident here for 21 years and counting.
Thank you. Pam.
See, I have to subtract things. My name is Pam Correndi, and I've been a resident here since 1991. We've had a home here, and we have lived here since 2015.
Steve Kaiser, full-time resident for about 9 years.
Hey, Augie.
Hi, August Flengy. We've had a house in Ocean Pines since 2014, and our part-time residents, we live and work in Arlington, Virginia, my wife and I and our 2 kids.
Perfect. Those are we are the 5 committee members. Now we'll introduce our board liaison.
Steve Jacobs, board liaison.
Thank you. And we do have some guests here today. Would you like to introduce yourself, please?
Yeah, I'm Colette Horn. I'm a member of the Ocean Pines Board of Directors, and I'm here because Resolution ML1 has been under review, and that was based on a first reading of edits that I submitted to the board a couple of months ago.
All right. Our next guest.
Jim Promo, resident full-time for 20 years in county.
And past chairperson of this committee. And we do have our virtual guest. Stuart, would you like to introduce yourself?
Yes, hi folks. My name's Stu Lackernick. I'm on the board of directors. I'm the secretary, and I'm just I watch every single one of your videos, and this one I could actually make in real time, so that's cool. Hi folks.
Thank you. Thank you. And our last guest.
Hi, I'm Cindy Hoffman. I'm with the Bayside Gazette.
Okay, thank you very much. So please look at, I have the agenda up on the screen. Let me scroll down a little bit. Is there anything that my committee members see on the agenda that they would like to add?
Motion to approve as.
About the agenda.
Second.
Okay. Any further discussion? All in favor of approving the agenda as presented, please say aye.
Aye.
Any opposed? Thank you. Always got to remember my timing. Got to give one time to respond. All right, so next item on our agenda is the approval of minutes from our last meeting, which yep.
Good job, Augie.
So
Yeah.
All right, so does anyone, I'm going to scroll down slowly, but does anyone see any corrections or have any comments about the minute that need to be corrected? This isn't about the actual discussions or anything like that. It's just, are the minutes correct?
I read the minutes, and as far as I'm concerned, I make a motion to approve them as written.
Second.
Any further discussion? In favor of approving the minutes as presented, please say aye.
Aye.
Any opposed? Thank you very much. Go back to the agenda. Okay, next up is public comments. Do any of the guests have any comments that they would like to make during this time? All right, so then we'll close the floor for the public comments. Next up is my report, because I always feel like we need to know what I am doing after the meetings. Not a whole lot this month, but I did get the agenda for this meeting emailed to Michelle, so that it's posted to the website. I didn't double check it, but I'm pretty sure it's there. And then later today or tomorrow, I will email out the approved minutes that we just approved to Michelle to have added to the website as well, because we only post the approved minutes, not the draft. And then I will be attending the next directors meeting, which is scheduled for March 18th. Okay, does anybody have any questions for me? Next on the agenda is I always give our board liaison an opportunity to give any report update for us. So Steve.
Thanks, Laura. I have today dropped off either charging documents or motions relating to adoption of resolutions for our governance matrix for B02, B03, B05, B06, B07, F03, and M05. I have two that I would hold for the April board meeting, simply because I don't want to overwork my colleagues on the board.
So when you say dropped off, you mean for the upcoming meeting?
Be put on, they should be added to the agenda for the March meeting. I have a charging document relating to F04 and F01.
And these are the ones you're holding on
And
to
I'm
for the
holding
moment.
for the April board meeting. I also,
And I'm sorry, I interrupted you. F04 and
F01. I also have, for the infamous unnamed F resolution, have a charging document for the agenda for the March board meeting. So that's really about it. Oh, Laura, I'll probably need to get you to, at some point, sign these two for the April board meeting. Anyway, that's what I got.
Okay, thank you very much. All right, at this moment, we will take a vote to suspend Robert's rules for the duration of our meeting, unless we need to, the committee members need to vote on anything. That will allow our guests to be able to interact with us without being out of turn, okay? So are my committee members okay with that?
Motion to approve.
Second.
Discussion? All in favor of suspending Robert's rules for until a vote is required by the committee members, please say aye.
Aye.
Any opposed? All right, thank you very much. Okay, so this is where it always gets a little trickier for me to figure out where we need to go. So I always just tend to put everything up on the agenda, and what we cover. Because between the time that I come up with the agenda and the time of our meetings, things can change greatly. So we have a couple of unfinished business tasks that I listed there. I don't know which order do we want to tackle these or Yeah.
Colette, were you here to address something specific that's already on the agenda?
Yeah, I was here for the MO1 and I guess the MO2. Those were both based on my first readings.
And are you able to stay the whole time, or would you be leaving after you were done? 'Cause
I would-
in other words, I would recommend we start with those.
Yeah, I would leave after we're done.
Okay, all right, so why don't we'll move forward with M01. Where's the charging that I have? Um, okay. All right, so. This one is to go over, the suggested changes by ARC. We're undertaking to bring procedures and practices in line with changes enacted by the Maryland legislature and signed into law by the governor effective of October 2022. So our concerns then, the committee shall consult, our committee would consult with ARC, and should it determine that the suggested changes raise particular concerns. I do not, while I'm looking to pull up the actual M01, does anybody want to start the discussion?
Did you send out that M01 red lines?
I think, it looks like I only might have done the charging
Sure.
documents, so let me figure out where M01. Is that one gonna be under declaration or the bylaws part? Which one am I gonna look under?
Were you looking
Well, it's
for-
under, I guess it's,
Let's go back here and see if I can find it. It's the one thing I haven't totally figured out. Let's see.
I know you sent a red line before our last meeting on
Yeah.
February 20th.
Yeah,
No, if
that's,
it's
yeah,
changed
I
since
think
then.
so.
Okay, so is this the one that I have up on the screen? Is that what we need?
yeah,
That looks familiar. Yes.
Okay. Because this has all the red lines in it, which is a lot of red.
Could you
No.
zoom into that just a little bit more, please? There
Yeah,
should be a plus
Let's
sign.
start. Which section do you want? You want to just start at the top? Or what are we? Let me see how we're.
Yeah, there you go. There.
Oh, that's better.
Or do you need one more?
No,
Let me see, Jim.
so the BODs were just administrative, right? Yeah. That's just wordsmithing. I think the same thing is true for the word property. I think it's just,
Right.
I don't think it's major, it's just clarifying.
So then it looks like number 3 has been struck. And then,
So.
I think that's because a full of some appeal process is set out in new language later in the proposal.
So that was original language, Augie? You know? What's struck out here, was that the original language?
I don't know
It's
the
like-
details of the procedure.
That was
It
the
original
original
language.
and Augie's right that it has to do with the fact that we refer to an appeal process later in the document.
Tell from here where we're at. So I have
I
a
think
comment.
we're,
4F and 4G, which is a minor. Paragraphs 4F and 4G. Definition.
4 ABC.
Yeah, we're not quite there yet.
Okay.
All right, you're down here.
We're almost there, Jim.
Do you want me to go
Hang
back
on,
up? just a
go back
little
up
bit?
just a little bit, please. Right there. So that's just administrative. That can be inspected. Verified.
Or do you want me to scroll down?
Do we do that now? Inspect milestones? Is this something new?
I think it was practice, but it wasn't enshrined
Hmm.
in the resolution. I think the issue being that sometimes when they inspect milestones, they discover things like the roof is too high. You know, that kind of thing that has to be corrected before the project is completed, or it's better to request that it be corrected prior to completion.
Right, yeah, makes sense.
This section here looks like it's been,
And so that strikeout there in paragraph F, that's original language?
Yes.
Here, again, typographical maybe. F and G, where you have the article reference. At the end, you have a capital B2 and capital B3, F, and then at B3 and G, it's a lowercase b and parentheses 2 and 3.
So where it says uppercase B2, that should be lowercase b in parentheses 2.
Next one is
Okay.
B, lowercase
I
b,
can
and
edit this.
parentheses 3 and G.
Okay, let me go to the copy that I can edit. Let's see if I can do that. So this is for F. Yeah, there it is. And then on G, it's lowercase b in parentheses 3. Got it. Oops.
In G there, the last sentence, to the address on record. Now, we made changes to a different bylaw where we got specific about how you notify people. Remember that? It had to do with where we mail ballots to.
right,
And it had to do with the language that said the address on record,
right,
you know, as provided by the individual, because if you have multiple properties, you may not be taking mail at that address,
right.
right? So since we're here, should that wording be tweaked? Because,
Doesn't it say that?
It's,
well,
Address on record?
that's the actual wording out of the code. B3 says, talking about sending out the notice of report at the alleged violator's address of record with a written notice alleging a set, so the code uses address of record.
I think that's what's in the Maryland homeowners.
that's what you mean, right,
Yeah.
Jim?
Yeah,
HOA Act?
yeah. That's
With that?
11B dash.
Okay.
Yeah.
11B dash, it would be 11.10.
Um, Is G all right then, or are we looking at H now? What are we, what is our, is our role today just to go over the red again and,
I think it's to prepare Steve or Colette to take it to the board for approval.
okay.
And
So
to
we
look
wanna make
for,
sure there's
So we're
no-
just kind of scanning it
Yeah.
and making sure it's
making
all ready
sure.
to go. Is what we're, okay,
and within the context of other work that we may have done in other
Right.
areas,
Right.
okay.
that's why I brought up that one issue, but if it's code, so.
It's eligible for approval at this coming board meeting.
Right.
Yes, if you guys
Ready for the second reading.
bless it.
If you want to take it.
Yeah, that's why I'm here, so that I can take it if you guys bless it. If you don't, then there's substantial work that needs to be done.
Right.
Then we'll go back to the drawing table.
This one's getting old enough to vote.
I would say so. Yeah, I think everybody's getting sick of this one.
Yeah.
For a second, when I finished.
Is H fine?
Okay.
Oh, it's been updated.
We get down to paragraph 5, I've got a comment.
Okay.
5D and 2 and 3.
Are you under number 5 with responsibilities? Is that where you are?
Wherever you are.
Okay,
I can't see.
gotcha.
Should complaints in paragraph C be capitalized?
Where are you at?
Paragraph C,
Okay.
third line.
Receipt and investigation. of-
Okay, I see.
That part.
I wonder if that's capitalized because it's defined in there. I don't know if that's usually.
Well, yeah,
practice.
so if it's a thing that this document defines, so that it's not just,
Yeah, it's defined in section 4 towards. the
okay.
end.
then it probably
Yeah,
should
so
be
I think that's
capitalized.
Formal complaint.
capitalized it. That was a good catch, though. I didn't notice that.
Hey, Jim, you had some questions?
Which ones did you have the questions about? Because they're lettered. We just looked at B. Now I got C up.
I'm good with.
I'm good with C.
It's okay.
Jim, do you have any questions? Your questions were,
Are we 5 now?
yeah, we're on 5.
All right. In 5D, 2 and 3,
Okay.
this deals with the art committee. And something that the art committee can do. In 3, it says authorize referral to the board for issuance of a second notice. It's an authorization that goes to the CPI. And that committee cannot authorize a staff operation to do anything. They can confirm it's continuing, and it is confirmed, at least in their opinion, it's a violation. But there should be no authorization to a staff function to take any action.
So he's on number 3.
You're on the new 3.
Yes,
Yes.
where it says starts with authorize the referral,
The referral
BOD,
board.
in all in red.
Yeah, that's all new.
And so you're saying under 3 that maybe that should say, instead of authorize, direct the issuance of a second notice? Or,
I'm just trying to stay technically correct with the governing documents.
Right.
Committee not be directing action by the board. I haven't tried to.
Recommend? they can recommend,
Or
so we could say that.
confirm, or
Confirm.
Yeah.
So let's say,
Yeah.
how about confirm? Is everybody okay with that?
Yeah, confirm would make sense.
Let me fix
So
that.
from the referral.
Would you rather have approved? Approving the total?
I don't think they get to approve either, I think. Jim is right. What do you think, Jim?
But who makes the referral to
Yeah, because they're,
ARC?
what were you saying?
Well, I mean, I thought what I heard Jim say was that ARC has no authority to authorize staff the issuance of a second notice. But the staff tell the committee, tell ARC that they prepared a second notice, in which case ARC would approve the referral to the board, which came from staff.
so
So can I tell you what happens in their meetings when they discuss these things?
Sure.
Okay, so what happens is that they
That's
review the status of the violations. The staff confirms that the violation still exists. And then the committee, I think, confirms that it's eligible to go to the next step in the process, basically, which would be the first violation or second violation, whatever, wherever it is in the process. So it's really, it's not directing, it is confirming that, yes, we
Yeah,
still have a
yeah.
problem, yes, it's.
I see what Jim is saying, because essentially you take a bunch of the words out, it says authorize the issuance of the second notice.
Yeah.
The way it's worded now. So, I
Right.
mean, this is just some wordsmithing here that,
But I think he's correct in pointing out that they don't have
right.
the authority to
Right.
authorize, but their job is clerical, so to speak, and that is to confirm, yes, we have a problem, and yes, the next step in the process will be X, Y, or Z.
Because the committee's action in confirming violation require a vote.
Yes, well, let me see, do they vote on that? I can't remember.
Of the committee.
Yeah.
Yeah, the vote of the
Yeah,
committee.
It's a vote.
Yeah.
Yeah, I think,
I'm somewhat at a loss to adequately come to grips with what confirm means, but if there's a vote, then you're approving, or disapproving, one or the other. Could say,
I'd have to add, I can't remember if they actually vote on that, or if it's more of a consensus.
Well, if they're
At
approving
the,
it,
at the board
At-
meeting itself.
No, this is at the
Within
ARC
the
meeting,
committee.
the committee.
the ARC meeting, when
Well-
they're reviewing these.
The way I read this is it's saying, we sent a first notice, and it's still violated, so now it's time for a second notice, but only the board can approve the sending of a second notice?
Well, the confirmation that a second notice is needed happens in the ARC. But with this new law now, that it has been determined that the second notice should come from the board,
Oh, I
because the
see.
board is
Okay.
required to give notice the opportunity to appeal, because continuing violations make
Right, yeah.
make homeowners subject to
Right.
restriction of membership rights.
So what we're saying here is, we're trying to define the tasks of the committee.
Right.
And so the committee has to indicate to the board that the conditions have been met for a second notice of violation.
Right,
It's,
yeah. And they don't, I don't think they usually vote on that. They vote on requests for variances usually, but this kind of stuff, it's more, yes, we all agree, it's time to go to the next step.
And
So
we've
it's
reviewed
more
the thing,
consent.
we've done the inspections, and it meets the
The criteria,
the criteria, right, for issuance of the second notice.
yeah.
So
when it's,
just to be clear, what you're saying is CPI under this construct, CPI would essentially say to the committee, we have 2, 3, 6, whatever number, where we're recommending issuance of a second notice by the board. And unless someone objects, it just passes on.
No, they look at each one.
Could you scroll back?
They don't look at 6. They go a violation by violation. They look at what the original violation was. And then now sometimes the ARC members go out and inspect to see if the violation still exists. But whoever goes
Go
out
up the document.
comes back and says, yes, as of today, that violation still exists. And so then it's by consensus, basically, that they say, okay, then, we need to take it to the next step in the process.
Well, okay, I mean, from my point of view, all I'm saying is there has to be some action taken by the committee in order for the second violation to get to the board. I don't know what, I think confirmation or confirming is sort of a fuzzy-wuzzy term. I think what you're saying is
recommend probably makes sense.
before it goes to, otherwise CPI can send it directly to the board.
So just for clarification, this section we're talking about is what the ARC is supposed to be doing, not
Yeah.
CPI.
That's my understanding.
Yeah,
Yeah, that's
Yeah.
my understanding. It's hard.
There
Yeah.
is no governing document requirement for ARC to be involved at all. So, you know.
But this change would do it.
I'm just addressing what you just said, though. Yes, CPI could send the first notice out, get no response to that first or unsatisfactory, whatever you want to call it. And then continue on to the board and the general manager with the fact of an unresolved first notice without any ARC involvement at all under the governing documents. It's what you want to put into M01 that we're talking about.
Which would be the governing document.
So it would add
It's not a
that.
governing document. It supports the governing documents, yeah, but there's no function in the governing documents for ARC to be involved in forwarding this kind of resolution of a violation.
Yeah, I was having a memory of when we redlined something else, and I think it's what Jim's referring to. Last year, remember how, it was a big discussion. One board members wrote up this whole list of what are we gonna do about all these violations and how can we address them quicker and how can we speed up the process? Remember that whole thing?
Mhm.
And we modified a document with some of that language, which sounds like what Jim is referring to. And that document talks about CPI and how CPI is going to manage it and go straight to the manager. And
Right.
so it almost sounds like 3 is not, that 3 doesn't need to be there. Like 3 is stepping in their business. CPI's business.
Stepping into CPI's business.
Yeah.
But the charter gives the authority to ARC for the enforcement of the DRs.
Would you?
Maybe I'm getting that mixed up with the DRs now, but I thought it.
Yeah.
Okay, all right. Well, you guys are the experts. So I'll defer to you.
All right, we've got
That's okay.
into this kind of detail. What we're talking about is what ARC's function in getting it further on. ARC is not in a position to be able to stop it. Let's put it that way. ARC can't.
So I think what
Yeah.
they're really in practice, having a senior moment here, Mr. Trumbull, on your first name. Sorry about that, Jim. That,
We just call them AU.
yeah. Yeah, so what in practice happens is that the CPI inspector brings the list of violations, photographs, documentation.
Right.
Shows them to ARC and says, this is still a violation. And so it's informing ARC that it's still a violation. And I don't know if you would say they're rubber stamping it or just affirming that, yes, keep on with the process.
Because ARC is the authority, so to speak, of the guidelines that are being violated, right? Is that the idea? So CPI is saying your guidelines are being violated,
Yes,
and ARC goes, yep, that looks correct to me. Looks like they
Yeah,
are being
exactly.
violated.
yeah,
Can I just jump in? If you look at C02, section 4E, it says the ARC is charged with reviewing violations identified by CPI and referring them to the general manager or the board.
That sounds right. That's
okay.
familiar.
So that's kind of what this is. It's
So that's
kind of confirming that we go to that next step in the process.
Where was the definition?
You moved it back off.
Where do you want?
Go back to where we were
All right, hold on.
there. Number 3.
Number 3.
So I guess in a way, authorized isn't. wrong if C.
Recommend
Two.
it, probably.
Recommend is.
Yeah,
right.
Yeah, because that's what this committee would do. If we think something should go to the attorney, we'd recommend to the board for legal review, but we can't tell the board. to have it reviewed.
Redundant in the terminology,
Yeah.
but what you're really saying is.
I think
Art
recommending
recommended
solves the problem.
Yeah, I mean, just quick and dirty, you could just replace authorize and recommend.
Yeah, that's what I would do, and
Yeah.
that's where we go.
Okay, I'll do
That's
that.
fine.
You're lucky. We could have talked about that for another hour.
You should have. I know you guys. I'm here.
I'm watching our clock. up
Are
there.
you? Okay. By the way, I'm sorry, I should have said this before. I have a hard stop at 3.
Okay.
I know we normally go to 6 now, but
Gosh, are you kidding me?
Doing 2 meetings instead of 1 a month.
We usually go to 3:30 or 4.
Or,
but
yeah, we've been running late.
We are dedicated people.
You
We
are.
meet on a regular basis.
I'll repeat.
You're a
Um,
ten.
Too frequently,
Let's look-
2 a month for a while.
Let's look at, and just make sure the rest of the document is good. Number 6 is general procedures.
Do you have any more there, Jim, that you caught?
B has the strikeout section.
Jim, wasn't there an issue? It seemed, again, I'm sorry. So last summer when we were doing all this CPI violation update stuff, seems like there was an issue with entering property. Wasn't there?
There was, and if I remember correctly, Jim, we got a legal opinion that we could, but I think it got enshrined in one of these resolutions that we could do that.
I don't remember.
Yeah.
This one, let me find it again in the draft memo of M01. And it does say there's authority to do it.
Yeah.
Okay.
And so they're acting as though they have that authority, probably. Based on my sitting in the room, hearing what they're doing.
If we get down to 6, step 3, I got a comment.
This section here.
Yeah.
6, step 3 was that rewritten? Oh, yeah.
When we get there.
Is it the new step 3 that you're looking at? Not all the crossed out stuff?
Oh, okay.
Okay, well, there's a lot on there.
Did we not already do that?
I thought we did.
Wasn't this already addressed earlier in the document? Or no? Maybe just in a shorter version?
No, I think the earlier document, there was a strikeout because you're coming to this.
Oh, yeah, that could.
Yeah.
Okay.
Here's the law, the original step 3. And then all of that is
Okay.
struck.
Okay.
And then here's the new, which I can't fit it all into one screen.
Take it as we go, but I think
It has a B in there, so. There you go.
You're at step 3 up there.
step 3.
Yeah.
I don't know if I have the right.
At the end of step 3, you have simultaneous with board notification of the need for a second amendment. Notice of violation. CPI/ARC will forward the case to the GM for further action. There's no reason for there to be alternates there. It was one or the other. Specify one or the other.
Is that what it says now?
At the end
CPI/ARC?
That's the last sentence.
second notice of violation.
Okay,
Our
second.
CPI/ARC will forward this. We've already got
Actually, it's in the clause above it.
Yeah,
CPI will notify Board of Directors to send a second notice of violation simultaneous with Board of Directors notification for need of a second violation. So that last clause is redundant, isn't it?
Yeah.
I agree. And I also, now I got a question. Why are we back to the CPI sending something to the board for the second notice of violation when we just talked for 20 minutes about the ARC doing it?
Well, because the issue was that ARC cannot instruct CPI to send something to the board. That's the original point that Jim made. But there's nothing that keeps CPI from sending something to the board through the general manager. That would be a staff function.
So if you look at that, then the part starting with CPI/R. Does that even need to be there?
What about the last clause?
Yeah,
Yeah, I think that's redundant.
if you read the first half and then you look at that, it looks like it's redundant. Unless I'm missing something.
Yeah, I don't understand the purpose of that. So, I'm not sure what we're doing in that last sentence.
Which last sentence are you
First
referring?
paragraph, last sentence.
Step 3, first
Step
paragraph.
3, yeah.
Okay.
I'm sorry, first paragraph on the screen. That's what I was looking
Yeah.
It's your new step 3, but at the very bottom of that first paragraph.
So what you're suggesting is to take that out?
Yeah, I don't know what it's there for.
Why the CPI notifies the board to
No, no,
send?
it's
What's the purpose of this whole sentence? What is it adding?
Let's go off right now.
Oh, that
Oh,
is
well,
because if there is no request for a hearing, or if the party does not respond to the second notice, then the GM can go ahead and take the next step. So the GM has it on his radar that he can, it's things like if there is debris that needs to be cleaned up and the property owner doesn't want to do that or just doesn't respond, the GM has the authority to send CPI in to clean up debris,
So,
that kind of thing. So he can go ahead and take that action.
so the way it's worded, and this is just the way it's translating in my head, is at the same time, we're gonna send this to the board so that the board can determine if they're gonna send out the second notice. At the same time, we're also gonna send it to the GM so the GM can take action. And I don't know why the GM would take action until the board has decided whether or not they're gonna send out the second notice.
Well, the board I don't think the board, that's optional. The second notice has to come from the board. That's not optional.
They can't decide not to.
No, they'd be overriding the CPI department's determination that there's still a violation.
In other words, it would seem like instead of saying for further action, if we said for consideration, there may not be any further action beyond the second notice. Sometimes the violation is of such a nature that there's nothing you're not gonna go on somebody's roof.
Right, yeah.
Fix the roof, right?
Right.
So.
Yeah, there are limited actions that the GM can take, but I think the idea was this would streamline the process, that there wouldn't have to be a
Yeah.
whole another meeting or something before the GM could
Right.
go to the next level.
I think that's a good idea. I'm just.
Yeah, but maybe consideration is the right thing because the GM isn't going to take action without determining within that 15 days, did the homeowner respond
Right.
to,
Or either to the GM for consideration or to the GM for further action as necessary or as required.
okay, yeah.
It just sort of makes it sound finite, like something's gonna happen.
Right, yeah. No, I think you're right. That's a good catch.
Jim,
What do you think, Jim?
I don't want. Some of this that we're talking about right now is further on in the resolution. Among the things that I wanted to comment on as we got further on, we may have to wait here a minute for to beat down the door.
Yeah, they're working outside.
There are parallel paths here. One path is a second notice to the board of directors that would be governed by the Homeowners Association Act provision that is behind some of this. The other is a compliance path. The board is a sanctions path. The other path is through the general manager to the attorney, which is a compliance path, which does not involve this Homeowners Association Act. And I believe that it's accurate to say that for some time, partly because of the pandemic and the effect on courts, that that path from the GM to the attorney to the court has not been used. The attorney in contact with, or making contact with violators, that was used. But there are two paths there. And I think we need to take cognizance of that. And in here, there is a provision, I can dig it out, I got it written down here, in which it goes to the board. And the board is expected to convene what I would prefer calling a hearing, a violation hearing, not an appeal. But the board is then expected to go that way and do that, in which the board may or not really want to do that until an attorney compliance path sees where it's going to go.
Well, except for the law gives us a timeline to do this. So we can't wait for the homeowner to, diddly around with the, kind of delay action.
That's when you notify the homeowner. You have a time, you have
Yeah.
You have a 10-day
Right.
sequence and everything. There's nothing in there that says you've got to go to the homeowner as soon as the board receives that. I don't see that being the case. But in fact, you're not doing that now. Now, you may not be doing that because you don't have this resolution in place. I understand that. But there was 2 meetings in a row where the ARC effectively and the board caught up with this suspension of the vote business and it went away. And that's probably the first time it's ever been used in the 20 years I've been here. I can't say that for a fact, but I have no recollection of it ever being used by the board. There's nothing on the board that says the board's got to implement that sanction.
Right.
My opinion.
That's true, but we're required by the new law to inform the homeowner that could happen, that's a possibility. And so it gives maybe weight to the importance of their making the correction to the violation.
Your description of the 2 tracks. Am I reading 3A as being essentially the compliance track that you're describing?
What step 3A and 3B are you?
3A, in cases where OPA or its designees now have the ability to correct violation, the general manager will notify OPA's legal counsel to begin the process of obtaining a court order to enforce compliance. Would that be the maintenance track that you're describing?
The compliance track.
So paragraph B is where we have the ability to correct the violation. Paragraph A is where we do not have the ability to correct the violation.
Okay. So here,
No. I think there's 2. That's what I'm asking you. 3A up here. Is that the description? All I'm asking you is that meant to be the compliance track that you described?
That's right.
Okay. And then 3B, which we're now looking at for the first time, the GM has the discretion to refrain from or delay forwarding the case to the legal counsel. Corrective action responsible unpaid fee retrieval. Okay. That's all part of the maintenance track.
Sanction track.
Sanction track.
I call them
Well, 3B.
compliance and sanction.
But 3B doesn't say anything about the board. It says the GM has the discretion.
Not sure I'm reading B the same way place you are.
Well, it says in cases where OPA has the ability to correct the violation.
All right. I'm not sure how to describe that. I want to point out here again is where the board and the GM have got to understand where each other is in this process. The GM may say or may think that it can be better taken care of by coming to the board for the authority to take whatever action is necessary, internal worker, contract worker, or whatever. So that it would be kind of pointless for the board to begin this sanction process by sending out the second notice to the violator. When the GM is going to come in and propose, let's fix it.
By the maintenance.
By our own
compliance.
action, somebody,
Yeah.
us or.
Well, that's what I'm asking you, because what confused, and I don't claim any great expertise in this, but 3B talks about OPA, not the board.
Okay,
Okay, so what I'm trying to grapple with is I understand what you're describing. That there's difference between forcing compliance and sanctions. Sanctions are essentially a penalty of some type.
Yeah.
Okay. So what I'm asking you is in 3A, and I'm not quite sure what 3B does, unless it's gets to the point you're making of trying to get the GM and the board to sort of get on the same page. But 3A, it seems to me, is the general manager's role to force compliance with the violations that are found, as opposed to instituting by the board any sanctions. So I'm assuming the sanctions are someplace further down in this draft.
We
I
need
think
a-
it's step 5 is sanctions.
you know, we need a chalkboard or something. You have a notice that the violation has not been corrected, well, whatever you want to
Right.
call it. It goes from CPI, I'm gonna say CPI, to the general manager. The same thing goes from CPI, art, whatever, but the same thing goes to the board of directors.
Right.
Now, the board of directors has only one thing to do at this point in time. And if they're gonna try to apply sanctions, they've got to go through the hearing process in the code. The general manager has to decide, is there a way to fix this without going to the attorney? Can I go to the board and fix this problem, charge the violator, whatever, the fees and so forth, put it on their invoice, that kind of thing? Or if I do not have that approach that I think is proper, I have to go to the attorney. So it's the GM is a fulcrum point, a pivot point there.
So,
If he's not gonna go to the board, he's gotta get it to the attorney.
right,
If he goes to the board, everything stops.
right. So he's the fork in the road.
He's the fork in the road. He goes to the board, everything stops.
The board then takes that.
The board says, yes, gets fixed, it's gone. The board says, no way, we're not doing anything about it. Well, then he's back to the attorney. The question at the board, what does the board do? In that case, as well as in the parallel case, he goes from I'm gonna say CPI to GM to attorney, CPI to board was already gone to the attorney. What's the board gonna do with it?
So what you're essentially saying, if I'm reading this correctly, is you need to insert another step. Right, if I understand, tell me, what I understand you to be saying is you need, once CPI makes its dual recommendation to the GM and to the board, there's another step that has to be put in there where the GM tells the board, I have referred this to the attorney, or I believe we can get this matter taken care of, as you described, through, fixing it ourselves and attaching it to the assessment or whatever. If the GM says, I don't think either one of those are doable, you board should take this up. And that's sort of what you're describing.
That's pretty close, yeah. I'm not gonna try to make it the same thing. It really, the way this is written, and really what's happening right now, again, the fact that we don't have a resolution in place right now can affect that. But what's happening now is they are going to the attorney, and some are in fact going to the circuit court in Snow Hill. I didn't look it up today, but as of yesterday, there had been 6 cases filed in circuit court.
Yeah.
Two have been dismissed, which I believe probably means, I don't know, probably means that they were brought in to compliance, but the people got the service of notice and said, oh boy, this is serious. I don't know that.
Right.
No, that is what happened. I know that about those cases.
2 have been dismissed, 2 are still open, and 2 as cases have been closed. But that doesn't mean the violations have been closed. The 2 were closed on the basis of orders from the court is what they had to do to close them.
Right.
It doesn't mean it's been done.
Right.
But right now, that is what's happening. Now, why there's only 6 when there are all kinds of outstanding CPI violations, I I don't know.
That has to do with, that's administrative. The lawyers are backlogged. Yeah, they don't have time
I
to file
understand.
all those cases.
I
Unfortunately,
understand. It's too many to get them all
Yeah.
at once.
To get a lawyer out of law school, but take care of those.
Yeah.
In here, it says the board is supposed to go forward with the sanction process, and I don't think that's necessary. I don't think that's good policy to have a compliance process going on, and then you can also have a sanctions process in place as well. Doing like further comments in here, I think that the membership, the board, and whomever else needs to understand that there are in fact two paths here that can be running simultaneously, and the policy is, do you want that sanctions process to be running or to be started and bring it to a conclusion of one kind or another while you have a compliance process going? Fine with me if that's what you want to do.
I think that's consistent with what the new law will allow us to do, because it gives 12 months
I'm sure you
to get
can.
correction.
I'm sure you can. The
Yeah.
question is, do you have to? And I don't think you
Right.
do. Or do you? Then it becomes, do you want to?
So really what you're saying is you may not necessarily have to change the language in this resolution, but there has to be, as a matter of practice, an understanding as to how the board and the GM are going to interact on proceeding either or I guess, with sanctions and or maintenance.
Yeah. I have a question. If that's the issue, and I can visually see the two paths, why don't you just put a diagram in there with paths to whatever, and then you see the GM's path and the board's path.
Well,
That makes it pretty clear about which path you're going on, or if you're going simultaneous.
Yeah, the ARC did create a flow chart that is a depiction of all from the point A to point B. And I don't think I have the current version on my computer.
Isn't that an attachment to the?
It was an attachment to,
It was included in the materials that were sent.
yeah. And so that exists.
Yeah, here it is.
Yeah,
So why are we struggling with the language? Why don't we just put it in there?
Sure, that chart helps.
yeah, I'm not,
Oh.
yeah, I think it's
It's a busy chart.
show
Oh.
what it looks like.
Yeah.
So just visually.
You know, we gotta assume that people are adults and that they're reading it. I'm assuming homeowners are adults and whatever. All right, so maybe they're not, but the point is.
Yeah.
It's
their
you
responsibility.
you can point to that chart and say, look, here's what's going on. And it's up to that individual to say, well, I don't understand it. That's how adults act.
Right.
Steve, I'm gonna address what you were talking about there. Okay, can you pick up step 4 on there, Laura?
This one here,
Yeah,
step 4, is that what you want?
yeah. In red, it'll be in red, I think.
Is that what you
All
want?
right.
You want step 4?
I'm gonna put my own words in here. Step 4 requires that there be, upon the failure of resolution on a first notice, step 4 requires a second notice, and the quote in there is, a second notice will result, the failure of the first notice to be complied with will result in a second notice sent by the board. That means second notice to the violator. That's specific. Do you really want that to be specific? That's my question. Shall be, will be sent, shall be sent, or does the board have the authority, either in the law or obviously has authority in resolution to change that and hold it under whatever time period, circumstances it so desires, and make a decision of when, how it's brought to the board for action? Is it a special meeting called by the president, 2 members of the board, or some other process? But do you want in there that when the board gets the notice, the first notice has not resolved, that you now need to send a second notice. Is that compulsory on the board? It is in the resolution.
So the question is whether it's shall or may.
The law says shall provide the alleged violator at the alleged with a written notice of the alleged violator's right to request a hearing. So what ARC was looking at is that second notice of violation serves the dual purpose of saying, here's your second notice, but you also have a right to appeal, to have a hearing based on the possibility that failure to comply after this notice may result in restriction of property
Is the
rights.
code saying that once you start a violation process, if it's not resolved, you must continue?
No, it doesn't. This
says you must continue. Internally, we must continue, but does the code say that a violation process, once it gets to a certain point, is no longer internal, it has to go external, not external. When I say external, I'm talking about external to the bureaucracy of the association, the board.
Well, it does say, it says within 12 months of the demand. So the first letter of notice of violation is in a sense the demand letter saying you need to fix this. And it says within 12 months of the demand, if the violation continues past the period allowed in the demand for abatement without penalty, or if the same rule is violated subsequently, the board shall provide the alleged violator a written notice of the right to a hearing. Now, it doesn't say that the board shall continue the violation process. It allows that the HOA to use their own process, but within their process, they need to follow these due process provisions.
I think that what that says is if you don't proceed to the second step within 12 months,
It goes away.
You're out. You can't. You got to start all over again. I think that's what that means. You've got 12 months to follow up on that first notice. If you don't follow up in 12 months, you're out of luck.
You start over.
You start all over.
Or you
That's what
let
that
it go.
means.
Yeah.
I don't think that's putting a requirement on the association to immediately proceed with the second notice. It certainly puts, I think, a statute of limitations on it.
Right.
If I can just jump in, I think those procedures apply if you look at B1, when the board is going to impose a fine, suspend voting, or infringe on any other right of a lot owner. So that's before the board can do any of that, that's when those other procedures are required. So I think to Jim's point, if for some reason the case is not pursued, I think the board can always just sort of not pursue a case if it's a minor thing or something that isn't worth pursuing.
Right. And paragraph A says, unless the declaration or bylaws state otherwise, the dispute settlement mechanism provided by this section is applicable to complaints or demands formally arising on or after January or October 1, 2022. We have a lot of due process or procedures in place. And this is meant only to incorporate the due process once you get to the point of having the option of restricting ownership rights as a sanction for continuing violations. So we get to follow our own rules. And once we get to the point of, okay, it's a continuing violation, then we have to do this other stuff. But I believe that the spirit of our governing documents has been, we would like to proceed through the process. We don't want to let people off the hook. And I'll tell you, the ARC and CPI don't want to let people off the hook. We're getting complaints from neighbors that we're ignoring stuff. And so they are very interested in having this be an efficient and timely process to resolution if resolution is going to happen, and that we not overlook things that we have the ability to get corrected in one way or the other. And I'll tell you, when you buy into an HOA, you buy into an HOA because they have rules like this. You want to have some rules and you want to have enforcement of those rules.
So that's what I remember from last summer when we were doing whatever work it was we were doing with CPI language, was we were actually trying to remove some flexibility that was had.
Right.
And try to drive some stakes into the ground. Because the perception was there was so much flexibility that potentially previous managers was not applying the same logic to all cases, and some were dragging on, some weren't. It wasn't consistent. And so,
Yeah.
With regard to the shalls and the wills and all that, I don't know, to be honest with you, I'm starting to lose track of the flow of this.
So do you want to have another month to look it over as a committee, or do you want me to go back to ARC and talk to
Well-
them about this, stalemate that we've reached today?
So just me, I'm not speaking for the committee, but just me. I'm not saying that this does not comply or conflicts with any other documents we have. I'm not saying that. I'm just saying, for me, which is what our task is, right? Our task is to make sure
Exactly.
we're not messing up something else that we've already done. So from that standpoint, I'm not sure I have necessarily any input on this. This discussion is wonderful, right? And I mean, I love listening to this, but it almost sounds to me like there's just more discussion, really by people with, your all's background, Jim's background, over what maybe this needs to be before it should come back to us. That's just my 2 cents.
I feel like we're in the weeds.
Well, I think, but part of this is that diagram that we just looked at. If you have two parallel systems in place, I think what a lot of Jim, and I'm not trying to minimize it, but I think what Jim is really saying is, if you look at this as it's laid out, it's sort of hard to figure, who it's sort of the, after you, Alphonse, no, after you, Gaston. I mean, I think what we're really saying, and maybe ARC needs to address this, is they need to, either before or after this, I guess at the same time this comes up before the board, there has to be something maybe attached to the flow chart that we all looked at, which suggests that while we recognize there are two parallel tracks here, the expectation is that the general manager and board will act in a way that conforms with a suitable practice on how to address the problem itself, which is the offending property. I'm not quite sure how to word it, but that would be the assumption.
And if the flow chart is so busy that people can't understand it, you just break up the flow chart.
Well, and I just looked at that. That's not a flow chart.
But whatever,
That's like a process chart.
well,
Yeah,
whatever
right.
you call it.
Yeah, it is.
There's
Right.
broken links in there. There's
Yeah.
dead ends. There's no flow. in
Okay,
that.
I misnomed it, whatever you want to call
Convert
it,
it.
but I
Convert it
think
to a
we
flow
should have
chart
some sort of,
and make it an
Yeah.
attachment.
I,
that's up to ARC, that's not up to us.
right,
No.
and I really like the focus that Jim put on the
Right.
basic high level two-path approach. There's two parallel paths, and I agree with you that a simple diagram, if we could get that into a diagram at a high level, 50,000 foot level, that this document can be greatly simplified then and just down to the legal
Mhm.
language that you need to put in there,
Right.
right?
So that could take out steps, these little I, little double I, and little.
I'm gonna suggest, I'm not sure you want to take out steps or anything like that.
Yeah, I'm not saying that.
All I'm saying is, I think you need something that attach, if not this chart, some other chart. I don't care what you call it. But you need something that captures what Jim is driving at.
Right.
which is There are two parallel tracks, both of which can proceed simultaneously. That's
Yeah.
clearly provided for. You're looking at the wrong thing. And in fact, the assumption is, and this can be done with an attachment, I think, with the chart.
Right.
That as a practice, the board and the general manager will find a way to lead with one step or the other step as appropriate, or however you want to say it. But that's up to Art to write. That's not up to us.
So why don't we send it back to Art with our recommendations?
Okay, so Jim, could you
You
just
are the chair of
articulate?
the art committee, right?
I'm
The
the
board
liaison.
liaison.
I'm the liaison, so that's why I'm here.
Right.
So if you could articulate to me in a way that I could take notes to take back
Okay.
the business of the two parallel processes. And I'm a good typist. I can type it down real fast and I can take it back accurately.
Years of practice, your other job.
I think 60 seconds or less, and I was telling my wife that, and she. For hours. To avoid future discussion or bringing it up sometime in the future, I think you should be considering, and this would apply to M02 as well, a separate resolution that deals with the actual, what I call violation hearing. It's an executive session, and that's not simply closing by different title.
Yeah, no, I agree. And ARC agrees, and they've been frustrated by the board not taking this up. And they realize the board needs to decide how they're going to deal with these hearings. But the board is acting like, well, nobody's asking for them, so we don't have to do anything. Wouldn't you say that? What's happening?
And tied to that is the latest comments as to whether or not this is even appropriate for the board. Maybe it's more operational than it is policy. Yeah, I mean, I think the board has to sort of fight with itself as to how it wants to proceed.
Yeah.
And I don't know exactly what's going to happen.
You go with the Article 6 interpretation being the board powers, the general manager doesn't have the authority to suspend by amenities usage, for example. That's a board power one.
Right.
But anyway.
Can I ask one clarification on the GM's parallel authority? Is the GM able to take these steps after the first notice, before the first notice, after the second notice, or at any time? That's one thing that I got kind of a little confused by the way step 3 is written.
He's advised that the first notice have made no progress.
Right. After the first notice.
When he gets a second notice.
Right.
Second notice didn't be issued. Let's put it that way.
Did you hear that, Augie?
Are you saying after issues of the second notice, or after something has gone to the board telling the board that the first notice hasn't been complied with? Those are two different points in time.
They are not necessarily two different points in time, but
Oh.
they do happen after the first notice has failed.
I got it.
Right. So after the first notice has failed to produce action, the case is eligible to go to the level of a second notice from the board. It's also eligible to go to the GM to decide, well, is this something we can fix and just bill the homeowner for? Or is it something we should go ahead and send to legal? But, so, Jim is right. It's a little confusing there.
I think that was a very clear explanation, and like some language like that in step 3 might be very helpful to go with, to kind of explain that those are both the parallel steps.
Do you agree with what I said, Jim? So can I type that down and say, if I can remember what I said?
You can always go back and rewatch the video.
That's true. I could do that. Now it's video. Yeah.
Finishing my 60 seconds, I think the committee should consider stating that whatever comes out of M01 that doesn't go on in the book of resolutions until it's signed by the council for the association. The affirmative approval of the resolution itself, or it says legal on the resolution, you should sign it.
Yeah, I think we talked about that in the last board meeting, didn't we? I was thinking we did.
I'm watching.
I sometimes get confused. What do we talk
Well,
about
that
in email?
was the change in the resolution dealing with, if referred to council,
Right,
he has to sign off on it. And if he attaches an opinion, it should be attached to the, it was in the book of resolutions.
One discussion.
Yeah, that's already, right, so what I think what Jim is saying is pursuant to B01, M01, to refer to council for review. And inclusion, council should include any opinion and sign. Is that, and that's something we can recommend.
Seems to me I want to say something else, but I think the separate resolution was apparently it.
yeah, and Art would love that. And I think, I think what we have is there's cultural diversity on our board. And one of the points of diversity is the degree to which each individual board member is comfortable with administrative burden and imposition of, adding rules and adding administrative procedures. Some people are more, you guys are all bylaws guys, you're probably comfortable with a lot of rules, regulations, that kind of stuff. They're in language that clearly articulates that. My observation is that there are members of the board who are very averse to that. And so that's, a cultural diversity that enters into the consideration of this kind of stuff. A lot of this was struck out, and in MO2, a lot of stuff was struck out because of that. I think, Steve, you correct me if I'm wrong, but because we were told that, we don't want all that. That's too much administrative burden. Or wouldn't you say that's kind of part of the
Yeah,
message
I
that
think
was
we're,
given?
of course, whatever we do with M02 is still a moving target. So
Right.
That's fine. The difference is that with M01 is we are required to bring our procedures in line with the Homeowners Act. So
Yeah.
that's a must do.
Right.
So they really don't have a choice. They've got to do it.
Right. But understand that, correct. But the Homeowners Act is, for lack of a better term, more broadly written than we're still required to bring procedures into line. So the procedures are going to be more specific than what's in the act itself. The act doesn't spell out all the procedures that are to be followed. But yeah, I understand what Jim is saying about another resolution.
Yeah, this is meant, ARC understood that they are not empowered to tell or even recommend to the board those procedures that Steve refers to. They just felt that it was important that the resolution that authorizes them to do what they do should give a reference to the fact that there's this law that does require some due process. And then, so it's kind of enshrined in their resolution that they acknowledge that this law must be followed, but then it's up to the board to do what they're going to do as far as creating the language, the more specific language and procedures.
M02.
Or M02 or a third is,
Yeah. Right.
Because M02 is really amenity.
Right.
And MO1 is ARC.
Right.
And our DRs state that property right restriction is, the law says, our governing documents say that continuing violation of the DR may make you subject to restriction of your membership rights, including voting and use of the amenities. Most of the violations are architectural. we've been dealing with those forever. But most of the DRs, if not all of them, also have a paragraph that talks about offensive or noxious behavior. And the complaints that the board gets that are not acted upon because we don't have a process or, I'm not sure what to deal with are the offensive and noxious behavior violations that people are continuously having, loud parties night after night, in the summer, particularly in some of these properties that are used as short-term rentals. And so the neighborhood has a reasonable right to expect that the HOA will take action to enforce that language in the DRs. And so this is, MO1 deals with architectural review violations, but MO2 deals with, we're attempting to bring language into MO2 to address the offensive and noxious behavior violation.
So I'm reminded of something that,
Well, that's amenities, right? Yeah.
You met him, man.
Yeah.
Yeah.
In the
No.
Yeah.
I'm reminded of something Steve said at the last meeting. And Steve was talking about with regard to the resolutions and the board. I mean, the resolutions reflect the will of the board, right? So what you said at the last meeting was the board is not operational.
Right, we would set policy.
So, because we were working on something else, I forget what it was, and we were starting to get too far in the weeds. And you said, no, that doesn't go in here, because that's up to the GM or whomever, right? So, I mean, the very title of this thing is compliance procedures. So just the title of it seems to me violates that notion. And I'm wondering if we're just going overboard here with this document.
Well, the short answer to that is, ultimately, from this committee's point of view, that's a reasonable question, but the ultimate decision is going to rest with the board. The fact of the matter is that because of the change in the statute, ARC has been charged and has produced a document which they believe brings our procedure into compliance with the statute. Statute's always going to rule over everything else that we do. So that's a basic requirement. Now, I mean, whether or not it's worthwhile to change the title because there's a distinction between policy and operations.
Well, that wasn't really my focus.
Right. But I'm just, what I'm saying to you is, as to N01, that is, we sort of have to come to grips with it based upon the change in the statute. Whether or not ultimately the board agrees that there should be a similar set of procedures in place for amenities or even neighborhood behavior, as Colette described, generally speaking, is sort of a separate, distinct question that we're not there yet. I pointed out on a couple of occasions, at least at the board meeting, that we should remember that in the two most recent court cases, the Janicek case and Rick Farr's case, the judge in both cases pointed out, there was a lack of what I refer to as due process. There was no appeals process in place. And we may have even done the same thing on the petition question about what the board could approve and not approve. But now those were not necessarily determinative to the decision reached by the court, but the court took notice of that gaping hole in the way we operate. Now, whether or not the board ultimately decides, should we have something? Shouldn't we have something? If we have something, is it operational versus policy? It sort of goes back to Jim's point about defining what the board does,
right,
as it applies to appeals. I don't know this for a fact, but I'm trying to do this from memory, but The statute generally refers to the board or appropriate governing body as the ultimate decision maker for homeowners associations. I don't think you can make the case that staff and or a committee, particularly an advisory committee, is in fact a governing body. I mean, I think that rests, we have a board, the board is charged, you know, that's sort of where the responsibility lies. But but as it applies to all the other amendments, we're not there yet. And that's something we got to face down the road.
See, it seems to me that the board has to realize that we've already stumbled on this several times, that we've got to have a clear path for these kinds of issues. Because if we don't, we're going to stumble again. And I think I understand the cultural diversity, that's called politics. And but you're derelict in duty for not providing a path, if it's two paths. You're derelict in duty if you don't follow up on it. And that's the board's job.
Yeah. Wow.
So the board, I don't know who tells the board what their job is. I assume Doug Parks does, but the cultural diversity doesn't exist here. You don't have that choice.
Right.
On this particular thing, it may on other things.
Well, as I say, I think as to M01, you know, you gotta bite the bullet one way or the other.
Yeah.
And the statute sort of lays out what we expect the governing body to do, and I think this is a good faith attempt to get us there. The other issues, I don't disagree with you.
No,
We're just that's down the road.
So what are we coming to here? What is the final solution to
Well,
this
as to
today?
M01, the issue for this committee is, you know, a review of what the artwork is, which is what we've been going through. And I think the one thing we would include would be pursuant to C01, that this should be referred to council. Council should render an opinion if necessary, and any sort of opinion should be appended to M01, and he should sign off on M01 when the board acts, you know, or I guess after the board acts, I guess is the way it would work. I'm not sure where it fits in the pecking order, but
So do we have to vote on that?
that's up to your chairman.
I've lost track where we are.
So
I think
The vote it would be, this is what we have decided to do as this committee. And we're going to send it back to ARC. And we're going to recommend to ARC that they send it to the lawyer and the lawyer signs it. And when it goes back to the board, I don't know how they can not act on it because the lawyer's already reviewed it.
right, yeah. So Pam,
Hmm.
in your recommendation back to ARC will be to make the revisions that I just typed notes on, right?
Yeah.
Okay.
And
Just to
I would
clarify.
clean up their, whatever that chart is. If somebody really had a busy brain putting it together, you can simplify it or put it on two, so that it makes sense.
Okay.
You know, I understand what they were doing.
Because the majority of people do not want to weed the room and
Exactly.
read all of it.
Right,
So
yeah.
a visual
Yeah.
aid
And so if,
helps explain all of this. So I get
Right.
where, you know, we want to clean it up, make it simple, make it understandable so that, you know, somebody who doesn't like to sit here for an hour and a half, talk about one particular document, you know, can say, oh, okay, I got this letter. Now I know my time's ticking and.
right,
this
And
is
you
what I
can
have to-
include, when you get that letter, you can include the flow chart.
right,
So that, I mean, not that one,
but the new one.
the new one.
So the question I have for you guys is, this flow chart has been worked over and over and over by ARC. It needs a new set of eyes. Would anybody in this room be willing to be that set of eyes? Kind of an independent look, not having been down in the weeds in this, just to kind of help them know that I mean, I'll give it another look. I'm not part of ARC. I wasn't, down in the weeds with preparing that. But sometimes you need somebody who's just looking at it logically rather than with a lot of history of the processes that they've followed and revised over the time that they've been on the committee.
Well, I was gonna offer that if Jim, hang on, would take a pencil and just crayon in on a piece of paper your thoughts on the two parallel paths and send that to me. I have a flowchart software program, and I could convert that
Okay,
into a draft
okay,
that you could take back and say, this is what we're thinking.
okay.
Perfect.
That'd be good.
Or even take.
And it could be as ugly, you don't have to worry about spelling, just
And see what.
just
you can tell.
draw the two paths and write in there what you think the major steps are, not the minor. That's
I know.
that's like for a worker bee, that chart
Yeah.
there.
Yeah.
But what we're talking about for this document would be
It's
at
a
a
high
high
level.
level.
Something that the homeowner can understand.
Yeah.
Yeah.
Because you got to feel the pulse of the community.
Right,
And the community's pulse, as I've experienced it, is they get really bent out of shape because you're picking on them.
Well,
ARC is picking on them. And
well, we also hear that ARC does nothing.
yes, that's
right, that's the other side of it.
Right.
And so, at least when you send out those notices, you send out the flow chart and hope for the best.
But
Yeah.
what you asked Jim to do makes sense. The other side is, why don't you and I take a look at what they have from our own standpoint?
I'm willing to go back, if somebody wants to send me a copy of that.
Yeah, I was gonna say, because.
Yeah.
do
I think
we
I
have
have it.
that?
It's not a flow chart, I agree with that.
Let me look.
It's like a process chart.
You were in the military.
Yeah.
I live with the Postal Service, and I'll tell you what, regulations are regulations, they need to be defined, and you need to
SOPs.
follow. And,
I was in the military also, and I've written a lot of SOPs.
Yeah.
so you
Okay,
understand.
so you have it.
Which would make
But
it so big.
I spent 50 years, 30 years dealing with the post office.
Right. So I've created a lot of flow charts.
Yeah.
So,
converting.
And you've got software that tells you something.
yeah.
Really,
So are we done with this particular issue? Did we make it clear?
I don't think we need a vote on it. I think it's
Yeah,
very
I
simple.
think it's
We
okay.
define what the
Right.
problem is. It's beyond our,
So basically, we're also saying this cannot go to the March director
No.
meeting.
It's not
Right.
ready.
Because
Yeah.
it's not ready.
Now, do you want it to come back to look at it again or just go to legal? You guys want to see it before it goes to legal?
Well, we can, I don't know what ARC can do. I'm not sure that we can send it to legal. We can only recommend to the board.
we can't send
Right.
anything. to
Yeah, right, but do you want to see it again?
I
Yeah.
think so.
I
Okay,
think so.
Yeah, I think.
so and you meet monthly?
We've been
Um,
meeting
Right now,
for 2 weeks.
twice a
Our
month.
Okay.
next
We're
one-
meeting twice a month, and today we accomplished
Okay,
Like-
one item.
yeah, sorry,
Our next
That's
meeting.
right. March 31, then
okay.
Now, when does ARC meet, and when can they put something together?
I think it's 31st.
You're gonna need her.
No, you can have it if you want to.
31st was our April monthly meeting.
Have you seen that?
Okay,
Yes, the colors.
it is 2:32. So, Keith and Bob will kind of work on the existing chart, we'll just call it that, and
Well, we'll
kind of
review it.
look at it.
Huh?
Yes,
We'll
you're
review it.
reviewing.
We'll review it, yeah, this,
Jim is hopefully going to be able to rough sketch an ideal
Very rough.
very,
Right. if you want.
explanation of the two paths.
Yeah, that's actually.
Right. And then Keith will use his software to turn it into a flow.
yeah, this is
And then-
not even close.
And then basically you're going to share the flow chart to this committee
Yep.
and send it to Colette.
Yep.
You wanna-
Share it With,
Who will share.
Copy it, scan, copy and send it to me.
I can do
so
that.
Yeah, that,
Say that again.
but no,
when,
We-
when Keith finishes the
you,
flow
you need a
chart,
clear policy.
he'll
And
send it to the
Jim
committee.
brought up the real
And
good points.
to you.
Points where you
And I can
drop
tell
it,
her.
or either You fix it here, you
Thank you
fix
so
it here,
much.
but you can't let it sit.
Volunteering.
Because as a property owner, I mean, I'm really disgusted when I walk around. I walk every day, 2 miles. And you see properties that are really questionable. I haven't taken the time to complain because I figure I'm not a neighbor. but the neighbors there, I don't see why they want to live with it.
You know, a lot of
None-
neighbors don't complain, Bob, because they don't want neighbor problems.
And the other side of it is, I would hate to be on a committee that you're kind of fighting against the wind. You know, you get all these complaints and you can't do anything about it, and the board is not helpless, but the board, there's nothing clearly that defines what action the board has to take because it's not documented.
But it does
Don't laugh,
tell
I
us
didn't
what we
say.
can take, what action we can take.
Yeah.
Right.
And so our is asking us to.
So we got to get the resolution.
Yeah.
And with as few loopholes as we can do it.
Yeah. And if, I mean,
Because somebody's gonna find a way around. That's just human
Oh,
nature.
yeah, absolutely.
Well, you can't make anything lawsuit proof.
Oh, I know.
Right.
no,
Yeah.
but I'll tell you what, you've been there twice, and I'll tell you what, you go again, the judge is gonna start saying, where are your procedures?
Yeah.
Right, yeah, we
It's
gotta
gonna come
fix
to
it
that.
for this.
And it's,
Stephen's right.
and there's too many word merchants out there that are looking for work.
Don't look at me, I'm retired.
I know. Excuse me, Augie.
Are you a lawyer too?
He's another lawyer.
All right. Okay, so,
So we're finished with that one for today.
Okay.
Okay. Thank you, Colette, for.
Let's run away, Colette. You
Yeah, and I
had two
think
of them. We met.
you
with
have
them
on
both.
memo two, no
We're gonna
action.
have that in the third meeting, no.
So I think you and I were working on MO two.
Yeah, and my recommendation at this point is just to leave it for now. MO2 is not ready for the committee to consider. So,
Right, okay.
There's more work being done. Other work groups are working on this. At some point, we will get a product, and at that point,
And then.
we'll have to probably have. a
Yes,
meeting.
and I have M02 as no action needed at this time. but
At
we're
this time,
waiting
that will
for-
be my
Other
recommendation.
stuff, yeah. Okay, well, thank you guys for doing mine first. I'm sorry, it took so
Pretty
long.
much the only,
No,
no.
I feel sorry for your committee members. I hate to be on that committee.
Yeah, it's so, I mean, it's
'Cause they-
such an eye opener for me as liaison to
Right.
see the frustration that they
Yeah.
experience and the attacks that they are subject to.
And
And just trying to do the best they can, and
Yeah.
they go out and look at these properties, they put a lot of time into this.
Right.
yeah, and they
Just
just
like
came
you
back
guys
with something about, don't you have anything else to do? And I'm like,
Exactly, yeah. And then we only have like an inspector and a half, I think. Or maybe at the most, two, which is not enough.
All right,
So
so.
Thank you, Colette.
thanks, Colette.
So looking at the rest of the
Yeah.
agenda,
In case
there
anybody
was
cares, 2:36. 3:00
3:00.
is the end, and you're at 2:36.
But he's at the.
He's at the end for sure.
Maybe do this F resolution next, because that should be a quick
yes,
Yeah.
Yeah.
thumbs up or thumbs down.
What are we talking?
is that,
The unnamed F resolution. you
Yeah,
said?
that has already been given for the
great, thanks.
It's already.
March.
Oh, Okay, so that one,
That's done.
that's done.
That's not.
I think the
Which
one
one
we've
is
got,
that one?
the unnamed F resolution.
What number again?
The unnamed one.
It doesn't
What am I
have a
pulling
number.
up?
Well, we were calling it F5, but it's just a charging document.
Okay.
All it is a charging
Yeah, and
document.
that's already on, that, I've given that to Linda to put on the board agenda for March.
Okay,
So, if I may, my suggestion, B03, which is also has been given to Linda.
Okay.
Because we had approved the red line version. And
That's right.
the discussion was, it came up last summer. It may have gotten tabled, it may have just been sort of left aside.
That's
There
right.
was no resolution, so I had sent the red line version out to all the board members with an email. And I said to them, "I'm putting this on the March agenda. It'll go as a first reading because Bylaws committee is essentially reconstituted. There's 3 new members of the board. So we'll do it as a first reading, and that's also been submitted to Linda for the March meeting. So
What date is that?
March 18th, 17th.
Yeah,
18th.
Highwood Derby.
What?
So,
So you have to
Cub
think
Scout
how
thing.
you say it. Everybody's really gonna be.
so I would, I think that the remaining unfinished business
It'd be nice.
is B9, the record retention, and you folks need to come to grips with what you want to recommend to the board.
So this, I sent you this, so this should be the most recent.
That's the one I have. Yeah.
um,
Draft 225.
No.
The one you sent me.
It should be draft 227.
Uh-oh. I can understand why you can't keep it straight. It takes me a day to put all these together.
Hold on 1 second.
I really wanted to learn how the organization runs. There's a lot of work here. I'm impressed.
If it weren't for Jim, if it weren't for Jim, we forget some of this.
Oh, this.
Oh, yeah.
This should
We're
be-
the either the
Huh?
largest or second largest planning community in the state of Maryland.
B9, yeah.
Wait a minute, what about Columbia?
That's your one day to 227, right?
the-
One day to 227.
Yeah. Yep. I got
I know.
it. All right. So this is
Okay.
the one that you have,
There you go.
right?
Right there. So let me just walk through real quick some of the changes. So I took what Steve sent out and then I messed with that a little bit. So let me just explain real quick.
Okay.
This sentence just seemed redundant to me, generated by the board and committee meetings. With this wording as established here, we don't need to change the title. I know, I get kind of nitpicky about titles, but I'm not hard over on this. This was just a suggestion here. This is the original title. If you scroll down just a little bit. Yeah, so Steve had put this down here at the bottom, and to me, it just made sense in the flow of logic to put it first. So this, the requirement, and so then if we do this, then we're gonna do these things. If we do this, then we're gonna do these things. So it's the same language, I just moved it
Okay.
I see.
to first in the flow. So scroll down a little bit more. I will say though, I mean, we can come back to this paragraph here. I don't understand this paragraph, but we'll say that there for just a minute. And then I think this down here was just administrative. I changed, the general manager there. They, and
Yeah.
general manager. And let's see, in the second and third sentence yeah, okay.
Yeah.
So the only thing on this page, and then the rest of it that I modified was the notes that we sent with it, where we had questions.
Yeah.
Right.
Right?
Mhm.
I've deleted this because I felt like we addressed that.
Mhm.
So that really wasn't even a question anymore. And I changed that based on Bob's recommendation to get specific there about statute. And then the change advised to recommendation. And then, and then that was
And that was it.
the quote. So really, the biggest change on the second page was just deleting that first section. The rest of it was kind of administrative. So for me, really, the only question was, if you would roll back up.
Where am I going?
Keep
Keep
going,
going.
keep going,
Keep going.
keep going, keep going, keep
Up
going.
to C,
Stop,
right there. C.
right, roll that just a little bit. This paragraph, and Pam actually brought this up. I don't understand it. It's like, well, if you want to do it, you can do it. You don't have to do it, but you can do it. And
Well-
but if you do it, then this is what we got to do with it.
Let me,
That could be.
my limited experience dealing with committees is, I've either served or I'm liaison with 3 different committees. This committee basically records and would look to archive, I think, for an extended period of time, maybe more than 2 months, the committee's deliberations. Communications committee meets only hybrid. I'm sorry, meets only
Virtual.
through Teams.
Mhm.
It's not a hybrid. They only meet through Teams.
They only need what?
Through Teams. So everything is
Virtual.
Virtual.
They
Oh,
only-
virtual.
Virtual.
Oh, I'm sorry.
Like Augie's doing, but
Yeah.
their whole committee. only
It's
does-
not a hybrid. So there's no
Yeah.
I got it.
physical presence.
Okay.
So anyway, they meet only through Teams, and they do not archive for any period of time their committee meetings. They are solely dependent upon their committee minutes. I served for a period of time on the golf committee. If you ever saw me play golf, you would wonder why, but I served for a period of time on the golf committee. They do not record, and the minutes, they again, just live by minutes, so they don't use anything. It's a, everybody shows up and they meet, that's it. I don't know what they did during the pandemic, that I wasn't there. So you have three different approaches. And so the sentence relating to the committees would be each committee shall decide whether to record their meetings. And then we'll inform the general manager through the board liaison, because that's the chain of communication of that decision. And then whether or not they're saved or not is what had previously been the bottom 2 points, or what was always sort of the blueprint we were working from anyway.
So I get all that. I guess the biggest part of that first sentence that I have an issue with, really, I guess the second sentence. Because if we're going to give the committees the leeway to determine on their own what they want to record, what they don't want to record, that may not be consistent throughout the year. They may decide to record in some meetings and not record others. So you got a requirement, they got to tell the general manager once a year what their decision is. That decision may change throughout the year.
Well, then they have to so inform. I mean,
Wouldn't they just reinform?
yeah, I mean, I
In
don't.
other words, does that need to be there?
Well,
Because that's operational, right?
well,
Could it say on at least an annual basis?
well, it is to the extent it's operational, to the extent that staff operates teams. I mean, that's the process we go through. General manager has said that for the committees, you can't have staff. Committees can't tell staff what to do. So everything has to come from the committee to the liaison, to the general manager, who then tells staff, this is what you're required to do. So if the committee says, I mean, I don't,
So then,
I'm fine leaving an annual, if you want to make it, any additional changes can be, referred appropriately to the general manager. That's
In a
fine.
timely fashion.
or how about we change it just generically to say something like, each committee will coordinate via their board liaison with the general manager on their recording needs. Just something very generic.
That's fine.
So it lays out the
But
report.
Augie's suggestion might be best, which is to say, at least on an annual basis. Otherwise, here's what I would be, and again, I didn't institute this, so I sort of fussed with it a little bit when it first came out, but prior to the pandemic, the committee's operation was pretty much restricted without a lot of staff activity. The pandemic created a situation where we had to meet, so the staff was much more involved. General manager's desire is to get back as close as we can to what it was pre-pandemic, so that the staff is free to do what the staff is supposed to be doing. Okay, makes sense. So I would say, in order to avoid, the committee going through the board liaison every month, say to the staff, say to the general manager, then tells the staff, we're going to report. Those next month, they're not going to report it. And I'm comfortable with Augie's suggestion, at least on an annual basis. That gives the committee a little bit more flexibility if they have to change.
Do we have to define what annual means though? Because even in our own situation here, our past chairperson didn't leave like in December because his term was up in October, right? So then he had already planned part of the last of the 2022 meetings. But then new chairperson comes in. I'm just thinking we might have an overlap. It may not, everybody may not be sending it all in January saying, here's all of our dates.
Why aren't you
So-
using fiscal year?
Well, just a minute. Every committee is going to have the same problem.
Right, because.
Because the
that-
chair will leave when his term is
So
up.
why don't
But you
we
always
say?
use a fiscal year. You don't have to do a calendar
Well,
year.
What's
Yeah, but part of the problem with that is
Because there's
the
elections.
the election takes place, the
Oh,
new
yeah.
board doesn't come in until
September, right.
Oh,
August.
Or as effective with the election,
Right.
Elections.
It's the election.
And the liaisons change and potentially the chairs change. What we could say is at least on a yearly basis.
Right,
Yeah.
whenever that's.
So let
Then
the
an update
committees
will
deal
be
with it
done.
on that
Right.
basis.
Yeah, yearly,
But I don't think it
makes
should
sense.
be implied that it's always gonna be
No.
January 1st when
Year-
everybody
yearly,
updates, because
if I answer the question,
July.
yearly,
Yeah, just say
Not-
and
Yearly?
on a yearly, at least on a yearly basis,
but
Right.
or at a minimum on a yearly
Yeah.
basis.
because I
And
would
then
agree,
update.
some committees don't want to record and they shouldn't have to record. And for
But if
us,
we
it
do
makes
record,
sense
we have to
because,
follow the rules.
right, they gotta follow whatever rules they agree to.
Uh,
Yeah, I think yearly works fine.
And that first sentence says each committee shall decide whether should it be it or should it be they?
Day. Yeah.
Who's
Yeah,
the
yeah, they, because all
That
the.
grammatician here?
Because they goes with each, right? Not
Right,
committee.
correct.
Yeah, they.
Okay.
Is someone making these changes?
Guess that would be me.
So whether
They.
I think it's it.
Good
Um,
catch. What?
You think it's it?
Each person is, each committee is.
Each will. All that stuff in the middle can be deleted. Each will record their meeting. Each is,
Yes.
right?
No,
Committee is singular, so wouldn't it be it?
it. Each committee
Each
it.
shall decide whether it will.
You know what, our
Committee,
kids would
yeah,
never
the
know
committee
the
is-
singular and plural.
All
Our
right.
kids today,
We'll leave it the way it is then.
Well,
Leave the way.
So what are we changing? Are we changing
Yearly,
the second
yearly.
to yearly?
at least, or at a
Each
minimum.
committee on a yearly basis.
Yeah, yearly, not annual.
All right. So, for-
somebody will come up and say,
Okay.
which year?
okay. Anything else on this document? That's-
You're right. You're right.
Well, the quick.
I think it looks great.
I would, by the way, for what it's worth, I agree with you. I don't care about the title. In deference to my president, who recorded, he wants it as records retention. That's the terminology he used.
Oh.
All right.
Did he, he
So-
didn't see this video recording.
So no to the title change.
Just, are,
Recording doesn't matter whether it's verbal or visual, so I don't care. I have no problem with it.
right, yeah.
Just say recording.
I don't understand what you're saying. The original title is records retention policy. Well, it's more than
Oh.
that now.
Yeah,
Now it's a recording policy.
It's a
Yeah.
recording policy though.
It's not just a records retention policy.
it's-
anymore.
Because all you're
Does
addressing
Doug
is
get
recording.
stuck on these things?
I don't know,
Oh.
but let him worry about it. If
I
you
mean, we
wanna
can send it to, I mean,
Yeah,
if we
it's
want that,
like it.
yeah, you can always strike it.
I mean, if you want to call it records and recording and records retention policy, that's fine.
Because it only talks about recording retention policy.
Well, no, because it also the minutes.
Yeah,
Okay.
And the
yeah,
minutes
The
are-
minutes, the minutes.
the
You're right,
minutes
you're
are-
right, you're right. I missed that.
Okay, so what about paragraph 1 as changed? Are you, everybody okay with it as it's currently changed, para 1?
Under the meeting section there.
Yeah, the way you, yeah.
I don't know.
Blue.
Go
No,
up.
we're starting at the top of the document.
Purpose.
right there.
Yeah,
Yes.
purpose.
Looks
Yeah.
good.
Are you good with it?
That's fine.
You good with it?
Yep.
Okay, so para 2, no changes to that.
Right.
Para 3, I didn't make any changes to that. 3A, I moved
Yeah.
the
Makes
thing
sense.
to number 1. Are we good with that?
Right.
Yep.
Yes.
Okay. Yes, Augie?
Yes. Looks great.
3B, I'm gonna leave it alone.
Yeah.
I'm gonna
leave it
change
alone.
annual to yearly, and other than that,
At least yearly.
Yeah,
At least, yeah, on at least
at
yearly basis.
least, gotcha, at least yearly basis. And other than that, it was just removing that to first in the, okay, we're good with that. Down in paragraph 4, it was just changing they to the general manager,
And we agree with that.
okay?
And then nothing changed.
So go down to the,
We
yeah, the notes.
amend our comments.
Is
right?
everybody okay with me removing the first question there?
Yeah.
And on the second question, I added in the specifics of the HOA Act, section 11B, 111,
Mhm.
instead of just saying statutes.
Mhm.
Well,
then,
let me, I sent out, I think, didn't I? Or I sent, or you were CC'd, I think,
Mhm.
the opinion from Jeremy as on this question.
Yes,
Yes. And, I didn't print it out, but
As I recall, he said it wasn't a problem.
right, I mean, I thought I made sure that everyone, I don't know.
Yeah, but I don't understand that answer.
Well, okay,
I mean, I understand what he's saying, but I don't see how that's correct. And I'm not a lawyer, but I mean, Bob said it pretty clearly last time. If we're gonna allow people to attend the annual meeting virtually, and anybody on that meeting refuses to consent to being
no,
recorded,
yeah, but I think what he's saying is, you're really talking a little bit about apples and oranges. The Maryland is a two-party consent state. But that does not necessarily take into account, meetings, larger meetings. It's really meant to deal with communications, party to party. And I think, you can't pick out what, or show, put what he,
hold on, I'll probably find it.
I think he also said something about the applicable statute, would governs us, the Homeowners Act, and that would not fall under the
okay.
umbrella of the two-party consent provision.
So if that's the case, then we could strike this paragraph.
I'm comfortable with that.
I-
Statement
I'll
up
give-
there.
We do have a copy of that, right? So if this,
Well, I don't know whether I sent a copy to Linda or she was already CC'd. But I thought you got something, you got what I got from Jeremy.
The email.
Yeah.
Mhm.
Do you have it?
Yeah, I have it up.
Oh, okay.
Here-
Here it is.
here's the answer. Right.
3 statutes. Criminal law article, neither one of which would really apply to us.
Okay.
3, I guess, inside of 3. I think he goes down further.
Owning or controlled.
Yeah, so willful interception of oral communications without both parties' consents.
Well,
Yeah, but see, he's talking about like, inadvertently picking up conversations. We specifically invited these people into our house. And now we're gonna record them. And they said, well, I don't want to be recorded.
Well, you can leave.
And what they can't. Because Maryland
Then
HOA
that
Act
takes
says
away
we have to
their-
have this meeting and we have to allow these people to attend.
Look,
Okay.
scroll down.
Keep going.
yeah,
Yeah, look, I mean, I'm comfortable with the legal opinion. If someone sues us,
As long as-
council's gonna have to come to grips with it.
but
That has-
would you not want to include that legal opinion as part of this
No,
to answer the
No.
question?
to me, you wouldn't. But,
Well, the way to make a test case out of it is for one person at the meeting that can't refuse attendance and hire a lawyer and see what happens.
Well,
The courts will have to decide.
Well, I guess here's the bottom line for us. We as a committee wanted to make sure the board addressed this question.
Right.
Technically, they did. They went to the council provided, whether we agree with that or not.
Right. We all have
That's-
to agree with it.
Right.
I mean,
Out of our hands then.
this second paragraph technically was addressed.
Right.
So I vote in favor.
The question I have is that legal opinion would only become pertinent if somebody files a lawsuit. And the judge said, is the judge not going to want to look at a legal opinion?
well,
Be
I
part
mean,
of
I
the
think,
case.
by itself, I'm not sure it would come into the case. I think what council, if we were to proceed for this at some point, would file an appropriate document, whether it's a motion to dismiss or a
Right.
failure to state a claim,
Response from
or
Jeremy.
whatever term you want to use, and they would delineate what is what, in part, what Jeremy has said about what is applicable and what isn't applicable. That would be the way I would look at it, but the question is whether or not the committee is comfortable with council's opinion as a means of, moving forward on this particular resolution, so.
Well, that's why we pay counsel. I mean, I'm not a lawyer, so I assume that he knows something more than I do. And he's not a nurse, and I can assure you, he doesn't know some of the things I know.
Yeah, I mean, I don't, right, I mean.
So leave it in or take it out. I gotta go in a few minutes.
Take it out.
Take it out.
Okay,
Take it
I'd
out.
say take it out.
okay.
Take it out.
So I'm Xing it out. So the last one here, though, is kind of similar in that the HOA Act says, and that's
Whoa,
the,
whoa, whoa. Slow down.
go down.
Wait a
You're
minute.
going the wrong way.
Yeah, you're going the
Wrong
wrong way.
way.
Go down.
Oh, into the comments?
Yes, we're in the comments. Go all the way down the bottom. Right, keep going.
Keep going.
Right there.
Hold it.
Yeah, that's as
Yeah.
far as it goes.
So, let's see, is it the HOA Act? No. But the bylaws says, section 7.01, essentially that books and records, whatever that means, and if we need to define that to make sure that everybody knows what that means, and maybe that's the answer, but of the association should be kept at such place or places as custodian therefore selects within the state of Maryland, all such books and records or copies thereof shall be made available on request to members of the association or their agent at any reasonable time.
Right.
And my only question is,
2
to the-
months from now, I could request to see something, but if our policy says it gets tossed after 1 month,
right,
we're not able to provide that request, that,
Right.
that opportunity to see those documents then because we got rid of it.
right. So basically, these videos that we're putting a timeline on for archival, are we going to consider those part of our records? If not, it's not a problem. But if we consider those part of our records,
Well, it's
Then-
the requirement, so how can it be part of the records?
The official,
The video
I
is
will tell you what the answer that I've gotten on this point is. First of all, well, the short answer is the minutes are considered to be the official records of both the board and the committees. The videos are helpful, but not required. So now, if there's a requirement in the act, and by the way, I don't think the act is involved, touches at all on the committees at all, in any way, shape, or form, other than to acknowledge they may exist. If there's something in our governing documents that require that the committee minutes be kept in perpetuity, that's a different issue. I don't know that there is, but there may be in terms of the board minutes. Again, board minutes would be, because they're the governing body.
Right.
right, so that's my question, because this is from our own bylaws. And it doesn't say board, it doesn't say committees, it just says books and records of the
Right.
association. So
Right.
forget about the videos, let's just talk about minute meetings. Are the meeting minutes from the committees considered part of the record?
And need to be kept.
Need to be kept.
Indefinitely, like,
Or do we need to go back and change the language in our bylaws?
to specify that it's directors.
Yeah, to make it okay that we get rid of them after 3 years.
Right.
Yeah,
Did we do?
My best guess at this point would be that a books and records request of the association would not encompass committee minutes.
But that's assuming books and records has a definition.
It does, yeah, a books and records request is, I think, in the homeowners act. If I'm not
It is,
So then,
it is in the homeowners
Yeah.
act.
so then,
I just don't know which ones we should find in Snow Hill.
Right.
so then that sounds to me like there is some tweaking that needs to be done in the bylaws, because books and records should be capitalized because it's a thing, right? Books and Records Act or Books and Records Request. Because
Augie's shaking his head.
Well, the answer,
the way it's written, it just sounds generic.
well, the
I
question,
mean, my reaction is this question should definitely go on, accompany whatever we send to the board, because it does seem like a question for council. I mean, we're
Good,
discussing
yeah.
the details, but it seems like a lawyer should look at it. And I'd
Yeah.
also reference the HOA, not just the bylaws in the question, in
Right.
case there's something that requires maintenance of the minutes of the board, which also are subject to a retention policy, not just the committee minutes.
Things, any recommended countries. On archival, well, I say down here, restrictions on archival of minutes or video recordings, and what did you say? Something else? The last sentence?
No, I think that's right. I mean, I think that's right. I would reference whether there's an HOA provision that requires maintaining the minutes.
Well, that's what this first paragraph is from, is our
I think we need HOA Act.
oh, HOA Act. Yeah, I don't think
HOA
so.
Act, sorry.
Yeah, I don't think that there is, but basically the bottom line for us is we're agreeing to leave this in here.
Right, yes.
So I'm gonna delete these two, I'm gonna leave this in
As an attachment.
as an attachment.
As an attachment.
What we met, board committee needs to vote. And then you need to send me the Word document. Cause I don't wanna keep going through this stuff. Whatever I need to
Yes.
craft a first reading for the board, and I will try to get it to Linda early next week. I'll let her know it's coming.
So I will, maybe not today, but at a minimum tomorrow,
That's fine.
Right,
I will clean this up of what we agreed to. I will send it back out to committee so anybody can look at it and agree that, yes, that's what we agreed to.
yeah.
Then once you see that, or you'll send it to
I'll
him
send it to Steve.
As a Word document.
as a Word document
With the attachment.
with the attachment.
Right.
All right,
I'll put a cover sheet on it.
okay.
And you're
Okay
gonna,
with you, I'll sign your name.
and you're gonna leave the
I
date
think
in
we
red,
started
because now I
to
can
every
read it.
document is supposed
I
to
gotta
be-
You're right.
I gotta change it. Well, once these,
Yeah, once you get rid of that, then it's
you'll be able to see
okay.
it. You'll be able to see it. And I'm gonna change the date to today
Right.
or tomorrow, whenever I.
Every
Yeah,
day.
just- And put.
That way I can keep track of which one I need to pull up. All right.
He can keep track of it.
So
Committee needs to vote.
I think because it's 3:06 and we have done a lot.
Committee needs to vote
Oh, we need to.
on this.
Okay, so we'll backtrack, I'm trying to think how to word this.
Well, I make a motion.
Okay,
You make the motion.
I make a motion that we agree to the changes as discussed on this document. And once the document is cleaned up, that it be provided to the liaison to forward to the board. Right.
Circulate, please, the amended document for approval.
For
Every
final-
committee member.
final look for.
Second.
Any further discussion?
Why are we calling it BL9? Is that the number we're gonna assign to it?
That's what it's,
Is there a BO9?
no, this is new.
I know.
No.
Is there a BO9 right now?
The highest one is no.
Is eight.
Is eight.
Okay, that's what I thought.
Yeah, I just picked. the next
Okay,
number.
that's fine.
Yeah,
That's fine. I,
Seven is still in use.
What 9 is?
8.
Oh, 8, yeah. Yeah,
so 9 is back. Yeah.
ethics.
8 was
Well, that's coming
suspended.
back.
Yeah.
Right.
You
And
guys already got
we
that.
it's still listed, we haven't even made.
We
it.
haven't voted yet.
So we have a motion still on the floor. Any further discussion? Okay, all in favor of approve? No, wait,
Aye.
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 Any opposed? All right.
Now-
You do a lot of work. I'm impressed.
What we could do is get Jim to vote, and that way we should question the integrity of the voting system.
All right, I am going to suggest, or get the, we know Keith needs to leave. Do we want to continue discussing anything else, or?
I make the motion
end
that we
today's
adjourn.
meeting and continue all of these discussions on the 31st?
Well, what do we have left? We just have
You-
new business, correct? And then the records retention.
I think about that.
I'm certainly.
And you still have a quorum, so you can carry on without me.
But we don't want to discuss your control document.
It's search committee, is that M09? Because we're calling this M09.
No, B,
P.
B, not
B.
Bob.
Oh, it's listed as M.
All right, oh,
No.
N09 is the resolution on candidate search process.
Yeah.
Is that what you?
Yeah.
Yeah,
The new business.
What used to be calling-
Well, my-
Oh, B, is-
My
I'm sorry, you're right,
question,
you're right.
yeah, it's confusing between B and C
I'm
and
sorry,
M.
you're right.
The question about this though is, I've seen advertisement now that the state OPA has, started advertising for search committee members. Okay, but then the election committee, I believe it would be the elections committee, has already advertised the process for this next coming election cycle with dates and everything already, and saying that the application is current and up to date on the website. That was advertised just the other day out on the web, so
The cart's in front of the horse.
yes. And that was prior to the election committee meeting this morning. That advertisement came out before their own election meeting,
Yeah.
committee meeting.
And is the right application published?
Well.
We'll see.
Sorry, gotta go.
um,
It's been
Can I-
great.
can I-
It's been real.
Okay,
Bye.
right, thank
Can I-
you.
Yeah.
Sure you can. So I don't even know.
My
what we can discuss.
My suggestion would be any further discussion relating to
And
N09 and any other new business should be put on bank till the meeting on the 31st, so we.
okay. We would like to invite,
Done.
No.
do we want, is that
We
what?
can't do that.
we
No,
don't-
you have to, if you're agreeable to doing that,
Mhm.
then if there's no other business, you could then go to adjourn.
Okay.
That is fine with me, do we want to, do we have a motion to adjourn the meeting?
Motion to adjourn.
All right, 3:11 PM, Augie. It's approved. All in favor, say aye.
I second.
Okay.
All right, now, Augie, if, once we, and now that this is ended, he's not gonna be able to hear us, so he
Right.
will not be able to participate
I know.
in this conversation.
If you want to,
Okay, all right, so we're calling it a day. We will reconvene, or well, not reconvene, but our next meeting then is the 31st, same time, hybrid.
place.
Just let me know if you gotta do virtual again, Augie, okay? So we can make sure you.
I can already tell you I will be in Kansas. But,
Yeah. There you go.
Lovely.
for a wedding.
That's why we love virtuals, because we can be anywhere. and still
Yeah.
have this,
Right.
Like, the pandemic opened wonderful doors.
All right.
Ready to
So
terminate it?
we're gonna end the meeting. I'm gonna end the Teams part. Okay, Augie, so have a good rest of your weekend.
Good to talk to everyone.
Thank you.
Yeah.